So I promised you that I would update you on this latest case filed against the Nissens for building a dock without Appalachian's permission. And I won't spend too much time on this, but I want to spend enough time so that you understand where we are today and where we're going to go in the future. It was back in the 3rd of October that Appalachian filed a lawsuit against Bill and Laura Nissen for building this dock, driving pilings, and they stopped them. And they accused at that point in time the Nissens of violating the Federal Power Act, of violating APCO's federal license and their shoreline management plan, and Appalachian's new interpretation of what the flowage easement really meant. Well, by now you should be pretty suspicious. You would recognize that the FERC can't change property rights with the award of a license, that APCO can't regulate non-licensees, third-party non-licensees like we are, unless they own the property or control it, which they don't in this case. So what did we do? The defense, the Nissens, had to file a motion to dismiss. They said, this doesn't make any sense. Number one, for 2 reasons. I'm a third-party non-licensee. I have not signed any permits. I have a flowage easement that allows me to access the lake for recreational purposes. In fact, I have a deed that shows that I own the land under the lake where my dock exists. Not that that's a big deal, but it makes it easier sometimes for people to realize how out of bounds Appalachian is. So he said, if I'm a third-party non-licensee, this case doesn't belong in federal court because you have no jurisdiction to rule on anything. This is not a federal issue. And furthermore, whether I violated the flowage easement or I didn't, and I don't believe I did, that's a determination that has to be made by the state court in Virginia. Well, we filed that particular motion back on the 16th of November. We didn't hear back from the court until the 2nd of February. So a couple of months passed, a little more than a couple of months. And Judge Moon, who now hears this case, and he's going to hear it in Lynchburg, came back and he said, well, you don't understand. Under Civil Procedure Rule 12b-6, I have to accept Appalachian's complaint at face value and assume that it's true. So once I do that, now we need to proceed on towards trial. So we deny the motion to dismiss at this point in time. It's premature, and let's move forward towards trial. And now Nissen file an answer to the original complaint and tell us what you agree with, tell the court what you agree with and what you disagree with. And so we did that. We filed that motion on the 13th of February, the day before Valentine's Day. And we, again, argued the same points. We said, this doesn't belong in your court because this is not a federal case. Nissen, as a third-party non-licensee, cannot possibly violate a federal statute that only applies to Appalachian. It's impossible. So on that alone, this case should be remanded to a state court because state court tells us that they have the rights to decide a flowage easement and what it means. And we've already explained what the Virginia Supreme Court's interpreted it to mean, and it's certainly a lot different than what Appalachian claims that it means. So we gave the judge 5 different separate motions for declaratory judgment in here. And what a declaratory judgment is, it says, Your Honor, there are no disputes of fact in this case. This is a matter of law, so you can rule on this, and we ask you to rule and grant us one of these 5 motions. The first motion, obviously, for declaratory judgment was Nissens are third-party non-licensees, consequently, no federal jurisdiction, and you need to remand this case back to the Virginia court system so we can determine the property rights of Nissen. That's the first one. If the judge decides, no, I think I can still hear it, we gave him another one. We said, well, okay, if you continue to think you can hear this case in federal court, a state court needs to first determine whether or not the flowage easement is subject to FERC's license order and the SMP. We already know the answer to that. FERC told us. They said, when we issue a license or an SMP, we don't change property rights. So we already know that it doesn't. And we said, Judge, if you believe that it does, it needs to go to state court because it's a property right issue. So please remand this case back to Virginia courts. The third motion, this is kind of an interesting motion. This is where we bring in the easement agreement now and the license or the permit that Appalachian wants us to sign. And we explain in this motion that the flowage easement only authorizes Appalachian to submerge a portion of the Nissen's property for the construction and operation of the project. The flowage easement only limits the Nissen's rights to their property insofar as those rights materially impact Appalachian's ability to flood up to the 800-foot contour. APCO does not hold the necessary property rights or sufficient rights, and as such, the Nissen property is not subject to the SMP. Now, the FERC has even told us that. They said if Appalachian doesn't have the property rights, they can't regulate property they don't control. Well, Nissen's property, they don't have the property rights. It shouldn't be subject to the SMP. Now, that's huge, that statement, because anybody with a flowage easement, and that's all of us in this room, have that same flowage easement. That means your property shouldn't be regulated by the SMP. It should be exempted from the SMP under FERC's guidance and under the law. And then we also explained that Appalachian is simply using its permit as a tool to acquire authority to regulate properties that are not subject to the SMP. Now, that's this agreement, that you agree they have the right to do this. Once you sign that and Appalachian collects $30 from you, and they file it in the court in the county of C.U.R.B with the county clerk, they immediately encumber your property rights, and that, by their own admission, is this permit is changing your property rights. It's black and white. I mean, it's indisputable. It's so clear. So hopefully that will get the judge's attention, and he'll look at that and say, well, maybe you've got something there. The fourth motion we made said, well, if still you're not convinced that this doesn't belong in your court, then what we need to do is because of this permit, there's an uncompensated taking of property rights here, and you can't do that. You need to be paid. The government or individuals can't take property from individuals unless they pay for it, or they get an agreement to take it. So if that's happened, the valuation of this taking, that needs to go back to state court. So the state court can determine what the value of that taking really amounts to, so that Mr. Nissen can be compensated for that taking. And then lastly, we point out that even if you don't believe any of those things, trust us that there are sufficient federal, state, and local regulations in place to regulate this project. We don't need an SMP because we have organizations like the Army Corps of Engineers. That is the regulatory authority under law. They have the authority and the police powers to regulate wetlands, to regulate dredging, and to regulate shoreline stabilization. No one else needs that power. Appalachians, the Corps has it already. We have the U.S. Coast Guard here at the lake that's responsible for navigation on a navigable body of water. We don't need Appalachians to regulate navigation here because we have that authority under the U.S. Coast Guard and under our DGIF, our Department of Game and Inland Fisheries in the state. We have the U.S. Fish and Wildlife Service in our project that regulates endangered species, protects wetlands and environments. The EPA, we fall under the EPA's regulations for water quality and wetlands protection. And those requirements are flowed from the EPA and the Corps and everyone else to our counties, to our state, and our state agencies, the Department of Conservation and Recreation, the Department of Game and Inland Fishery, and the Department of Environmental Quality all develop regulations that they impose upon the counties, and the counties have the personnel in place to enforce erosion and sedimentation, to enforce stormwater management, to regulate the uses in the project on the project boundary. They've all been there. That's the way we did it from 1960 through 2003. And believe me, this lake in 2003 was a heck of a lot better off than it is today under Appalachian's regulations, because it's our lake, it's owned, the waters are owned by the Commonwealth, and there's no one that exists that I believe that owns property on this lake that wants to damage it environmentally or in any way impair it, because that would decrease their values. So we say, send it back to the Virginia Supreme Court and let them adjudicate these property rights and these issues. And there's no reason for Appalachian to change property rights here or to even go for permits. So we've given the judge 5 opportunities. What's this mean? Where do we go from here? Well, C.U.R.B has collected funds and helped support the lawsuit. It's a costly thing, but we've collected funds and we've stayed ahead of the legal bills, and we're still ahead of them. We're going to need more money, and we'll make a plea to you tonight to help continue to support us in any manner you can. But we're going the distance on this. We figure that worst case, we lose in this court in Richmond or in Lynchburg, and we have to appeal to the Fourth Circuit Court of Appeals in Richmond. If Appalachian loses, they're going to appeal. So we have to be prepared to address an appeal to that body. And that body is a more deliberative body than the district court. They have justices that consider all aspects of the law. So in this lawsuit, we need to make sure that all of our arguments and all the evidence and all the law is clearly spelled out, and we've done that. I believe we've got a very comprehensive filing here that lays it all out.